During your medical malpractice lawsuit, the defense attorney has an opportunity to question you during the pretrial litigation process known as a deposition. When the defense attorney turns around and asks you to tell him what happened, you want to know why I would object and why that's an inappropriate question? Come join me for a moment as I share with you the answer to this question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and let me share with you the answer to that question. When you are called to give testimony, it's pretrial testimony, which carries the same exact weight as if you are testifying at trial. During the course of your medical malpractice lawsuit, you will be asked to give testimony in your attorney's office. Now, the only difference is there's no judge there, there's no jury there. But the attorney is going to be there. The defense lawyer will be asking you questions. If the defense attorney were to turn to you and say, "Hey, Mrs. Jones, tell me what happened," you know why I would object? And why I would argue that that's an inappropriate question? It's because that calls for a long-winded narrative explanation. Now, what does that mean? Well, if the defense attorney is opening the door and allowing you to go ahead and tell him what happened from the very beginning all the way through to the very end, we're going to be there for at least 2 hours having you explain every single detail that happened, every step along that timeline. And now he's going to take you through every single step of your answer and ask you tens and hundreds of questions that is going to keep you there for hours and hours, and probably will have you come back the following day to continue on answering his questions. All because you answered his question about, "Tell me what happened." Now, can the defense attorney do that? Yes, he can do that. And yes, you have to answer the question as truthfully and as honestly as possible. But one thing I may suggest is that if he asks that type of question, I'll say, "Listen, I object to the form of the question, but if you wanted to answer in a narrative answer, then I'm going to suggest you can't go back and ask her 500 other questions about everything she just answered." The better practice, you will find that the best trial attorneys, the best lawyers, are ones who focus on individual things that they're looking for. "Mrs. Jones, let's focus on this doctor's treatment. Let's go through the first visit. What complaints did you make? What did the doctor do? What problems did you have after the visit? Let's move on to the next doctor." And now you take it sequence by sequence because it gives the attorney a better understanding of exactly what happened, rather than rely on the injured victim to tell the story in their own words from start to finish, which is really a long-winded explanation that tells it from the viewpoint of the injured patient. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own particular matter. Well, if you're thinking about bringing a lawsuit, but you haven't done so yet, and you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.